on the, even write on the laptop, write on the mobile with the pen which I use to write in the notebooks. I'm just giving an example. So I'll get it protected on my name. So anyone who want to launch my product into the market will have to take a permission from me for launching that product into the market. So that is why it is a set of exclusive rights granted by Government of India. As a inventor of any of the idea, for example, I am citing an example of a pen. So I get the set of exclusive rights which are granted by Government of India for a limited period of time. The limited period of time is 20 years, excluding others. So excluding others from making, selling, using, importing. So in India, anybody wants to launch that product into the market will have to take a prior permission from me, will have to make an agreement with me to launch that product into the market. So that is what is a patent. That is how patent gives a protection to your invention. Patentee is a person whom the patent is granted. Suppose I received the patent for protecting my invention, I am a patentee. And types of patent are utility patent, design patent, plant patent, and microorganism. Next slide, please. So Kanchan, do we have the engineering students? Do we have students from pharmacy or biotechnology in the meeting? Can anyone tell me that do we have students of biotechnology or pharmacy in the meeting?
No, ma'am, mostly students are from finance and management.
Okay, all right. So we will be talking only about utility patent and design patent. For the reason the next two patents, they are concerned with pharmacy and biotechnology students. So we will be concentrating our lecture today on utility patent and design patent. So utility patent protects new and valuable discoveries such as machinery, composition of materials, methods or improvements. Utility patent are also known as the patent for an invention. Example is the anti-cancer drug, protected for its unique formulation. Then is BT cotton technology, recognized for enhancing pest resistance. So being a management student, being the finance students, so most of the patents, if you want to protect your idea, you will be going for a utility patent, right? Because when we talk about the management students, when we talk about the finance students, so you can create new processes. It may be a business process. It may be, for example, moving forward for the compliance of a startup. You can create a new method. You can create a new app for that, which can be a part of the utility patent, right? And if I talk about design patent, suppose you have created a product, a prototype, which will, help you in addressing some business concerns, or which will help you in addressing some financial concerns, right? Then you can go for a design patent of that. Utility patent is basically for an idea or for a process. Aapne koi process, you want to move ahead with the process of registering a company. This is just an example which I'm giving because I belong to engineering background. So I'm giving you simple examples for management or for the finance. So for the registering of a company or for ensuring a product, आपने कोई नया एक method you have devised, then you can go for a utility patent. And suppose you have made a product, आपने कोई एक product बनाया है, you have created a machine which helps you in easing your business, which helps you in easing your financial calculation. That product can be protected under the design patent. उसको हम design patent के under we can get it protected. Is it clear to everybody? Just give me a thumbs up if it is clear. Okay, thank you. All right. So next slide, please. So we'll not be talking about the plant patent and microorganism because these are basically concerned with pharmacy and the biotechnology students or the agriculture engineering students. Next slide, please.
Some biomedical students are here also.
Okay, all right. So talking about plant patent, a plant patent is an intellectual property right that safeguards the unique characteristics of a new plant, preventing others from copying, selling, or using it without permission. Plant patent grants exclusive rights to inventors who discover or develop novel plant species. So suppose you have created a hybrid species or a new species. Generally, the Punjab Agriculture University is working on protecting the plant inventions. So then you can go for a plant patent. For example, is high yield hybrid rice variety Pusa 44, Kesar mango, colorful Gerbera daisies, pest resistant type of eggplant. So it is like a novel plant you have developed, a hybrid version of a plant which you have developed. You can go for protecting the invention. Though living beings, they cannot be patented, but if you have developed a hybrid version of a plant, you can just get it protected because of the unique characteristics of a new plant. So the protection will be on safeguarding the unique characteristics of a new plant. So this is how you can get the plant patent. Next is for the microorganisms. Patents for microorganisms are allowed under Patent Act 1970, meaning that genetically modified microorganisms or microbe-based processes can be patented, while naturally occurring microorganisms cannot be patented. So suppose you have a genetically modified microorganism, you have developed a genetically modified microorganism. First thing is that you need to deposit the genetically modified microorganism with the IDA, which is the International Depository Authority. And after that, you can go for the filing of your patent for the microorganism. And this is not for the naturally occurring microorganisms. They cannot be patented. If there is any genetically modified microorganism, that can be patented. So even for the plant type, it is the hybrid plant and the unique characteristics of new plant are patented. Similarly, for the microorganism, you need to deposit the microorganism with the International Depository Authority, and then you can get it patented, right? And your nearest this IDA, that is Intech Chandigarh, they have this International Depository Authority where you can deposit the microorganism, giving all the details of the genetically modified microorganisms while depositing your microorganism there, right? Next slide, please. So legal requirements, whenever you go for protecting your idea, whether you are the management student or the finance student or an engineering student or like from pharmacy or biotechnology, the first thing is it should be novel. कोई भी आप invention को you want to go ahead by protecting the invention on your name, first thing is it should be novel. That is, the invention must be new and not disclosed in any prior art. For that, what you can do, whatever you think of protecting, कोई आप research statement पे काम कर रहे हैं, you are working on any genetically modified microorganism, you are working on any hybrid plant, what you have to do is just search over Google patents about the idea which you want to get protected on, so that you can have a prior idea that is your invention patentable or not. So suppose I want to go for the patent filing of a specs मैंने जो spectacles होते हैं मैंने patent filing करनी है उसकी. So I want to make AI based spectacles, right? I just Google it over there, and if there are a lot of inventions, the similar inventions on which I am working, this means I cannot protect the invention on my name because the invention is already there in the market. And suppose there is any novel idea which is not a part of the inventions which are being shown by Google patents, then you can go for protecting your invention. And as a third party, as a IP company, we support you, we help you to just support you for getting an idea that your invention can be protected or not. तो अगर आपकी कोई invention है, we send you IDA form, which is the invention disclosure form, where you pen down your idea that yes, this is my idea and this is the work on which I want to go for protecting my idea, and then we can search for you, and we can give you the result that whether your idea is patentable or not, right? Next is the inventive step. Obviously, अगर कोई आपने idea को protect करना है, if you want to go for protecting your idea, it should have an inventive step. Without the inventive step, you cannot protect your idea. कोई नई चीज नहीं होगी तो obviously idea protect नहीं होगा. Next is industrial applicability. So it should be useful to the community. It should be useful in the industry, in any kind of industry. If you are the management students, तो management industry है, जो business processes हैं, business के लिए फायदे का होना चाहिए. It is not that you have protected, you are just moving forward with the invention with no use. So that cannot be patented. Any invention you want to go for protection, it should have the industrial applicability. Disclosure requirements: the patent application must fully describe the invention so that person skilled in the field can replicate it. So your patent application, when you are going for protecting your idea, should fully describe the invention, so that suppose I want to replicate the idea, I want to prepare the product after having an agreement with you, I can prepare the product just by following your patent application, just by referring to your patent application. That is why the patent application must fully describe the invention. Unity of invention: a single patent application should relate to one invention. So if there is one patent application, there should be one invention. One invention is protected for one patent application. That is why many of the, if I talk about mobile phone, so there are n number of patent applications for one mobile phone. For the reason, because if a mobile phone has 10 patent applications, this means 10 of the inventions of mobile phone are protected. One patent application protects one invention. That is known as the unity of invention. Ownership: obviously it should be owned by you. So there are two fields when we go for a patent application. One is name of the applicant, and second is name of the inventor. If the university is paying for your patent application, obviously the applicant is the university, and you all who are working on that problem will be the inventors in that part. If there is a startup, we recommend that the applicant should be the startup founder, or the name of the startup should be the applicant for that particular invention, right? Territorial scope: so if I am filing a patent in India, I'll get a protection of my product only in India. So if I want to launch the same product in the US, then I have to file a patent application in the US as well for protecting my idea. Right? Next slide, please. So step-by-step patent filing process. So I'll be just telling you the steps of patent filing. So first thing is checking the eligibility. So that is, you need to check whether your invention is novel, it is non-obvious, it has a practical application. Then only we will go to the step 2. First is checking the eligibility. Second, next, then is conduct a patent search. So perform a prior art search to ensure no existing patent or publication describes your invention. And this is done by, on our part as a third party, we tell you that yes, your invention is patentable or not. This helps avoid duplication and strengthens your application. So conducting a patent search will give you a fair idea that yes, your invention is patentable or not. Next slide, please. Then next is preparing the patent application. So draft a detailed specification of your invention. The application can be provisional specification or a complete specification. Generally, the pharmacy students or the biotechnology students, because they have most of the work which is in the lab, they go for the provisional application first. So provisional application is filed just to protect your invention. And in the provisional application, not all the details are provided because your work is not completed. But yes, you know that this is the work which I want to go for the protection of my invention on my name. So you file a provisional application, and within 12 months, you can file the complete specification. So you have a window of 12 months जहाँ पे आप complete specification जो है, complete application को file कर सकते हो. So it is like a temporary application and then filing a final application. So temporary application is the provisional application जहाँ पे you give little bit details about your invention and you file the provisional application, and within 12 months, then you can go for a complete specification. Talking about the management students and the finance students, they go for the complete specification because they are pretty clear about what the business process is, what the financial उनका क्या protection है, invention है जिसके आगे वो आगे जाना चाह रहे हैं, then they go for the complete specification. And going for the complete specification, the key parts which are required from your side is the title of the invention, abstract, summary of the invention. Abstract आपने इस तरह से लिखना है कि एक layman भी आपकी invention के बारे he should know about your invention. He is able to understand your invention. So this is how you need to write the abstract. Claims, these are the most important part of your patent application. And generally claims are designed, claims are written by the IP expert, drawings which illustrate the invention. So either go for a provisional or the complete specification. Next slide, please. Next is, so you first thing is preparing the patent application. Now you file the patent application. So submit the patent application to Indian Patent Office. You can file it online via IP India e-filing system. Offline filing is also done, but it's good to go for the online filing at this point of time. And online filing, the charges are 1600 rupees. The government fee hai, that is 1600 rupees. And offline filing, 10% extra hai from the online filing. So if it is 1600 to 1600 plus 10% of 1600, that is your offline fee for the filing of the patent application. Next is the publication of the application. So there are two ways of publishing the patent application. One is a natural way कि आपने file किया patent application को, and within 18 months आपकी जो application है that will be published online. Another way is going through a shorter route where you request for early publication, and generally the startups, they go for a shorter route where they request for early publication. Even the universities go for a shorter route where they request for the early publication, and then the application is published within 1.5 months. So you can go for early publication where the application gets published in 1.5 months, or you can go for a natural way of publication, which is after 18 months. When we go for early publication, then you have to pay the government fee, which is 2500 rupees. And if you go for a natural mode of publication, which is a window of 18 months, then there is no fee. So filing of patent application, next is publication of patent application. So once the application is published, your application can be viewed by anyone over the IP India website, and any person who wish to challenge your application, who wish to challenge your invention, can go for the opposition to your invention. And if there is no opposition, then we go for the request for examination. So request for examination, it is filed within 31 months from the date of filing of your application. Now we have a provision where we can go for the request for expedited examination, but not all the inventors can go for expedited examination. Only the women entrepreneurs or the government organizations can go for the request for expedited examination. Otherwise, we have to go for the request for examination, and you have to pay the fee for the request for while you will be going for the request for examination. And request for examination will happen only once the application is published over the public domain. So the steps are filing, next is publication, next is going for request for examination. Once we file request for examination, your application goes to the IP India, IP India team, where there is a controller who has your application and which is forwarded to the examiner. The examiner checks your application and asks if there are some doubts by or some questions by the controller, then the questions are sent to you and you have to respond to the examination report. So step 7 is responding to the examination report. The examiner issues the first examination report highlighting the objection. You have to respond to the objection within 6 months, and amendments may be required to clarify or modify the claims. So as the IP company, generally we help the inventors to respond to the examination report. Next step, please. Next is the grant of the patent. So if everything goes well, if the examiner is satisfied with the responses which are sent by you, then your application is granted. And once your application is granted, a certificate is issued. It's a big thing to have the application granted on your name. The invention is protected for next 20 years. Application is protected on your name, and then you have to pay the annuity fee. Annual maintenance fee आपको pay करनी पड़ती है till 20 years, so that the invention is protected on your name. So these are the steps for the patent filing. Vanshika, can you go to the step 1? We can have a quick review of. So checking the eligibility. Next is conducting a patent search. Next is preparing the patent application. You can move forward with the provisional application or a complete specification. Next, please. Filing the patent application, publishing the application. Next slide, please. Requesting for examination, responding to the examination report, grant of the patent, and paying the annuity fee. So these are the steps for the patent filing. And please tell me, Kanchan, wherever I need to stop, just let me know the time when I need to stop, right? Next slide, please. So key forms for the patent filing. These are the key forms which are used for filing a patent application. Form 1 is application for a patent. Form 2 is filing a provisional or a complete specification. Form 3, it is statement of undertaking regarding foreign filing. So if you want to go for a foreign filing, you need to give a statement to the controller that yes, I want to go for a foreign filing. But even if you are not going for the foreign filing, you need to attach this Form 3, which is statement of undertaking regarding foreign filings. Form 5 is declaration of inventorship. So who all are inventors? You need to file Form 5 for that. Form 8A, this is certificate of inventorship. So universities are generally the applicants when they are paying for the patent application. And inventors, they can apply for the certificate of inventorship. Moving forward, they can apply for the certificate of inventorship, where they get a certificate that this student is the inventor for this invention, which you can like just show to the experts during your placements or during your interviews. And this gives you an extra edge to your application since you have worked on an invention. Form 9 is request for early publication. Form 18 is request for examination. Form 18A, it is for the expedited examination. Generally, the startups, they go for the expedited examination. Next slide, please. So copyright protection in India, copyright, it is a legal right that protects original works of authorship such as books, music, even your presentation, you can get it copyrighted, software, artistic creation. So giving the creator the exclusive right to use, reproduce, and distribute their work. This is governed by the Copyright Act 1957, valid for life of author plus 60 years. And this is automatically granted upon the creation. Next slide, please. So this is an example of copyright protection. I think I'll wrap up by 12:05. 12:05 I'll wrap up. So this is the copyright protection example. D series uses YouTube content ID and legal notices to take down unauthorized uploads of its music. So you might have seen even in the Instagram, you have the Instagram library where you can use the songs. Tips, they have just added the songs to the Instagram library, which you can use. Otherwise, the unauthorized use of the music, it is prohibited. Urta Punjab leak, the film was leaked before release. Producers used copyright law to block the pirated content online. So this is how the copyright protection is used. CBSE sent legal notices to the coaching centers for selling and copying exam papers and using the CBSE logo without permission. So even the logo, this Niti Aayog logo, you cannot use the logo without permission. So this is the copyright protection. Next slide, please. Trademark, it is a unique sign, name, logo, sound, or word that distinguishes one company's goods or services from another. For example, you can see the logo of my company. This is trademark. Nike logo, swoosh, everybody knows about that. That is trademarked. Jitne bhi logos hain of big companies in the market, they go for the trademark. And most of the time it is a trademark war between two companies. If there is a dispute, family dispute between company, then it is always the legal dispute because of the trademark, where one of the family member want to take a trademark, because trademark gives a visibility to your company, gives a name to your company. वहां से आप पहचान सकते हो कि yes, this is a company जहां से मैंने अपना प्रोडक्ट को खरीदना है, right? Next slide, please. So this is an example, Haldiram versus Haldiram Bhujiawala. So you can see the difference. Generally, whenever we think of Haldiram, it is always the red logo, which is in our mind. And we go to the shop. Agar is tarah se do shops ho, Haldiram Bhujiawala and Haldiram, obviously we prefer going to the shop which has a red logo. So this is how these two shops are from the same family. Both the owners, they are the brothers. But obviously, we prefer going to the Haldiram logo with the red mark. Then Flipkart's Big Billion Day, Flipkart trademarked this phrase and took action against other retailers. So Big Billion Day, this is also trademarked. Then Dettol by Reckitt Benckiser, Dettol's color, shape of bottle, logo are trademarked. They won cases against counterfeit hygiene products in India. So everything in the bottle Dettol, that is trademarked. Next slide, please. So this is, I'll just wrap up with this example, though I have other slides as well, but it's all up to you. If Kanchan, the time is over, then I'll wrap up after this slide. Vanshika, just message me if the time is over. I'll just wrap up with this slide. So this is understanding IP with an example. The best example is the Coca-Cola bottle. If you see the bottle cap technology, it is patented. So you can see this bottle cap, this is patented, right? Next is the brand name and the logo. It is trademark. The name Coca-Cola and its iconic logo are registered trademarks. These protect the brand identity and prevent unauthorized use of others. So first example was patent, which was the bottle cap technology, which was innovation related to the design and functionality of the bottle cap. That was patented. If I talk about brand name and logo, that is trademark. Then the bottle shape, the design of the bottle shape, it is protected under the industrial design, because it is the bottle shape. Whenever we think of Coca-Cola, हमारे को पहचान है, we know about the bottle, that this is the bottle which we can relate it to the Coca-Cola drink. So bottle shape, it is protected under the design right. Then packaging and advertising content, this is copyrighted. So the packaging design of Coca-Cola and creative element, that is copyrighted. Then the trade secret, it is a formula. The formula how the Coca-Cola is made, the production method, these are trade secret. The secret recipe for Coca-Cola unique flavor is closely guarded trade secret. So this is a trade secret. So this is the best example of the IP protection, where the bottle design is protected by patent filing, by industrial design, by copywriting, by trade secret, by moving forward for the trademark protection. Is it clear to everyone? Is it clear? Okay, all right. Next slide, please. So this is another example where ITC Limited took legal action against Nestle India because ITC used the name Magic Masala for its Sunfeast Yippee noodles. So we have this product, Sunfeast Yippee noodles, while Nestle used Magical Masala for Maggi noodles. So we have another product, the similar product, which is Maggi noodles. So ITC used the name Magic Masala for Sunfeast Yippee noodles, while Nestle used Magical Masala for Maggi noodles. Now ITC claimed that Nestle's name was too similar and could confuse the customers. So the Madras High Court said that the words magic or magical with masala are common and descriptive, so no one can own them exclusively. The court found no confusion or passing off and ruled it in favor of Nestle. So these are two noodles, varieties of noodles. Yippee uses the magic masala as the as the advertising phrase, and magical masala, it is used by Maggi. But the court favored Nestle in this quoting that magical masala and magic masala, these are two different names, and even the magical masala can be used for advertising of the separate product which is not a part of ITC. So the decision was passed in the favor of Nestle, that is in the favor of Maggi for the magical masala. Is it clear? Okay, all right. Next slide, please. So then there are two products, Amul versus Emulati. Now this Emulati, this is a Italian company brand which markets cookies and biscuits under the name Emulati. And then we have this Amul. I think everybody knows about Amul. We have lot of dairy products in the name of Amul, and this Amul objected to the logo of Emulati because somewhere Emulati, the logo which is this given by Emulati, it is the same as that of Amul and it resembles Amul. So the court favored Amul in this, and Emulati has to change the logo because of this is known as a brand war in the courtroom, where Emulati has to renounce this logo because Amul, the decision was passed in the favor of Amul for this. Next slide, please. So this is a trademark dispute between Nestle and Cadbury, and this is about the shape of Kit Kat chocolate bar. So Nestle had registered the four-fingered Kit Kat shape in 1995, claiming it had become distinctive long-term use. Cadbury challenged the registration, arguing that shape was functional and necessary for consumption, not uniquely identifying the product. So the decision was passed in favor of Cadbury, where the court ruled that Kit Kat shape lacked distinctiveness and was primarily functional. It is used just to facilitate the eating of the chocolate. So the decision was passed in favor of Cadbury. Why I am telling you these examples are so that you get a fair idea how you need to protect your invention. So there are a lot of trade wars which can give you a lot of ideas about how you can go for the patent filing. Even the phrase can be protected. Even the design, the logo, the shape of your invention can be protected, right? Next slide, please. So this is a utility patent on pharmaceutical innovations. This is how you get a US patent. There is a name of the assignee, then the application number, filed on which date, and pharmaceutical compounds, they receive the utility patent. Generally, they go for the utility patent. For instance, a new drug with unique health benefits can be patented, protecting the inventor's right and fostering healthcare innovation. So this is how the students of pharmacy, they can go for the a patent on the pharmaceutical products. Next slide, please. So these are the software example patents, and recently the government of India has launched the computer related inventions, which are known as the CRI inventions, because in India the issue is that the software cannot be patented. अगर आपने एक simple program लिखा है तो वो patent नहीं हो सकता यहाँ पे. And generally the programmers and the developers, they go for filing their protection for their program in the US, and so there are some inventions, there are some amendments to the computer related inventions where the patent can be now, because of the amendments, we can file the patent in India, but yes, the invention जो भी program आपने बनाया है, that has to be a part of some technical invention. टेक्निकल पार्ट का अगर वो पार्ट है, देन वी कैन गेट योर सॉफ्टवेयर प्रोग्राम को आप जो है उसको पेटेंट फाइल कर सकते हैं. अदरवाइज वी गो फॉर कॉपीराइटिंग ऑफ द सॉफ्टवेयर प्रोग्राम्स. जितने भी आपके प्रोग्राम हैं, दे गो फॉर द कॉपीराइटिंग. एंड दीज आर टू एग्जांपल्स. ग्लीन स्टार्टअप, the patent was filed, that was filed in the US, and then Microsoft generative AI for game narratives, the patent was filed. And not in India, but yes, I'm just giving you the software examples so that you are well aware that programs cannot be patented in India, they go for the copywriting. But if program is a part of technical invention, then you can go for the patent filing of the program in India. Next slide, please. So this is all. Next is about publication. Just for the faculty members, I can tell you that before going for publication, always go for a patent first, because it's good to go for, it's good to protect your idea. It's good to protect your invention under your name before launching it into the public domain. So for the faculty members, if you are planning for publishing your work, it's good to go for patent filing first. Otherwise, within 1 year of publishing of your work, your idea can be patented. But अगर आपने अभी तक publish नहीं किया है and you have this knowledge that yes, my idea can be protected on my name by going for a patent filing first, then it's preferred कि पहले patent filing के लिए अपना protection को, अपनी invention को protect कीजिए, and then you go for the publishing of your work, right? So this is all. Vanshika, come to the last slide, please. The last slide. The last slide. Thank you slide, if you can just come. Yeah, thank you so much. And I expect 2 to 3 questions from your side. And Vanshika will share the presentation with Kanchan ma'am. And you can just take the presentation. आप अपने पास रख सकते हैं. You can refer to the presentation if you want. And if you want to go ahead with the patent filing, you can always contact us for that. And I'll be happy to answer the questions. Muddat Agarwal, I think he has a question. Yeah. Good afternoon. Yeah. रिन्यूअल का कॉस्ट होता है. देयर इज अ रिन्यूअल कॉस्ट. या जो आप इनोवेशन है उसी के ऊपर ही आप पेटेंट फाइलिंग करते हो मुदित. सो योर इनोवेशन इज प्रोटेक्टेड by filing a patent, and you are, if the university is the one which is paying for your invention, then obviously the university will be the applicant. The person who pays generally, universities generally, they want to go for, being an applicant in the patent filing, and then you are the inventor for the application. ठीक है. And आपको एक certificate मिलता है of inventorship for filing the patent application on your name. And the patent application, it talks about your innovation. Suppose I have मेरी एक innovation है about a pen. So I drafted an application, patent application, and I filed a patent application, and I was inventor while filing my innovation, while filing my patent application. Then once the patent application is published, I can apply for the certificate of inventorship for that. Is it clear? Yeah. Yeah, you can definitely get the certificate of inventorship. And if you are paying for your invention, you just be an applicant for your invention, no? If you are the one who is paying for the invention, then you will be the applicant for your invention. आप applicant होंगे उसके लिए. तो then the patent application will be on your name. Obviously, आपको जो certificate of grant मिलेगा वो आप ही के नाम पे मिलेगा. Any other question? No questions? Okay, so Vanshika will be sharing the presentation, and it was an absolute pleasure, giving a lecture to the students. I have been working in the academic field for 24 years, so I always feel, rejuvenated when I talk to students. and looking forward for like if you connect with me, and we can go ahead with the patent filing for your inventions. Thank you so much. Thank you, Kanchan. Thank you so much.
As we come to the end of this meaningful session, I would like to extend our heartfelt gratitude to Dr. Ruchi Singla ma'am for sharing her knowledge about the IPR. Your session has truly enlightened us, and we are grateful for the time and effort you dedicated to us today. Thank you, ma'am.
Thank you so much. Bye bye.